The California Privacy Rights Act, or CPRA, represents a major shift in how employers must handle employee data. As of 2023, employee and applicant personal information is no longer exempt from California privacy law. For employers, this means new legal obligations, new compliance risks, and new responsibilities for HR, payroll, and management teams. In this video, we'll walk through what the CPRA is, when it applies, what employee data is covered, and the practical steps California employers should take to stay compliant. The CPRA expands the California Consumer Privacy Act, or CCPA. While the CCPA originally focused on consumer data, the CPRA fully extended privacy rights to employees, job applicants, contractors, and former workers starting January 1, 2023, with enforcement beginning July 1, 2023. This means employee personal information now receives the same protections as customer data. Employers must provide privacy notices, honor data access and deletion requests, and implement formal data governance and security practices. For small and mid-sized businesses, this is a significant operational change. The CPRA applies to for-profit businesses operating in California that meet any one of these thresholds. If your business has annual gross revenue of $25 million or more, or buys, sells, or shares personal information of 100,000 or more California residents, or derives 50% or more of its revenue from selling or sharing personal information. A critical HR point, the 100,000 record threshold includes employees, job applicants, contractors, and even dependents, not just customers. Companies using applicant tracking systems, payroll software, or analytics tools can reach this threshold faster than expected. Even employers headquartered outside California may be covered if they have California-based employees. The CPRA covers nearly all personal information collected in the employment relationship. This includes basic information like names, addresses, email addresses, and phone numbers, social security numbers and government IDs, resumes and job applications, payroll and compensation data, benefits and timekeeping records, performance reviews, disciplinary records, and internal emails or communications. The CPRA also introduces a special category called Sensitive Personal Information, or SPI. This includes social security numbers, financial account credentials, precise geolocation data, biometric data, health information, union membership, and private communications. Sensitive data requires enhanced protection and limited use. California employees now have enforceable privacy rights. These include the right to know what data is collected and how it's used, the right to access copies of their information, the right to delete data subject to legal exceptions, the right to correct inaccurate data, the right to limit the use of sensitive personal information, the right to opt out of data sharing or selling, and the right to non-discrimination for exercising these rights. Employers must be prepared to respond to these requests properly and on time. First, employers must provide a privacy notice at collection. This notice must be given at or before collecting employee or applicant data, including during hiring, onboarding, benefits enrollment, or workplace monitoring. It must explain what data is collected, why it's used, who it's shared with, how long it's retained, and how employees can exercise their rights. Second, privacy policies must be updated at least annually and include employee and applicant disclosures. Third, employers must have a data subject request process in place. Requests must be handled within 45 days with proper identity verification and documentation. Fourth, vendor contracts matter. Payroll providers, HR systems, benefits administrators, and background check vendors must have CPRA-compliant contract language limiting data use and requiring security safeguards. Finally, employers must know where employee data lives. Data mapping, retention schedules, and reasonable security measures like access controls, encryption, and training are essential. Practical steps include confirming whether the CPRA applies to your business, conducting a full data audit, drafting employee privacy notices, reviewing vendor contracts, minimizing unnecessary data collection, and training HR and managers. Common mistakes include ignoring remote California employees, forgetting former employees or job applicants, assuming old vendor contracts are compliant, and overlooking internal communications like email and messaging platforms. CPRA compliance is not just about avoiding penalties. Though fines can reach thousands of dollars per violation per employee, It's also about building trust, improving data security, and preparing for a future where employee privacy laws continue to expand. By treating employee data with care, transparency, and respect, California employers can reduce legal risk while strengthening workplace culture. In today's regulatory environment, protecting employee privacy isn't just good law, it's good business. For more HR resources, compliance guides, and expert insights, visit kphr.com. KPHR, your trusted partner in HR, payroll, and workplace compliance.